Greetings and good day, ladies and gentlemen. We are talking about, this is a CRJS, criminal justice 220, courts and the judicial process. This is our textbook, Criminal Courts, a Contemporary Perspective, fourth edition, by Hemmings, Brody, and Spawn. This is the textbook from which I've created my class lectures. So I'm about to do chapter 3 now. So this is the chapter 3 lecture. In chapter 3, we're talking about the types of law, criminal and civil. So we're going to break this down today. Criminal law. So when we talk about criminal law, first we have to ask ourselves, what is a crime? Um, a crime is an act in violation of a criminal law for which a punishment is prescribed or stated. The person committing it must have intended to do so and to have done so without having a legally acceptable defense or justification. That is like the book's definition of crime when it says what is a crime, and it's right there in the book. So make sure you're reading. Um, Also, a violation of that written or unwritten contract between each individual and the rest of society. So, in earlier chapters, I talked about laws being like an unwritten contract between some kind of that uh, contract of living, right? As individual citizens who have to share this earth with other people, uh, we're all subject to having certain responsibilities. They're rights we have, right? But with rights also come responsibilities, and that's the responsibility not to do certain things that could harm other people, um, and like murdering people, right? That's a responsibility. So if you violate that murder law, you've now violated that contract where you said, "Hey, as a part of living amongst society, I promise not to kill anyone." So that when I say that violation of that written or unwritten contract between us as individuals and the rest of society. That's what I'm talking about. I'm essentially talking about you following that code of conduct. So that's what we're talking about. That's what a crime is. So a crime is essentially when you violate a criminal law or you violate that contract, that invisible contract between you and everyone else. Well, it's not really invisible because crimes, of course, are on the book. As the definition said, um, it's a violation of a law that's written, of course, and the punishment is prescribed or written. So we're also put on notice by the codifying or the writing down and putting and reduced to books of criminal law. So that puts us on notice. Sources of criminal law. You have criminal statutes and ordinances. That means you have lawmaking bodies that tell you what's legal and what's illegal and what the punishment is. And you have codes, whether it be model penal code or different penal codes that apply state by state, and there's even a federal criminal code as well. So that's a source. Statutes. So when I say statutes, that's legislatively or laws made by a legislative body that have been reduced to writing. That's a statute or code. That's the first source of criminal law. The second source is common law or court law. With common law, those are it's usually adopted by most jurisdictions, and sometimes it's changed. But a lot of our criminal laws had their impetus or beginning from the English common law, and even sometimes further back than that, and they made it across the sea when America was created, or when America uh, um, declared its independence, then created a constitutional government. So that's common law, and we say common law because common law is also court laws, what courts have defined. Courts can give definition to laws as well. So you have statutes and common law slash case law. So who versus who? And this is something I've added. You're not going to find this in the book, but just to give us explanation. In criminal law, because the court system, whether criminal or civil, is always adversarial. You have one side you have one interest on one side versus another interest. It is always a dispute. So you have one party versus another party. So in criminal law, it's who versus who. Who are the who's, right? Um, in criminal law is everybody else or the interest of the state as a whole or the community as a whole versus you or me or that one individual or individuals or entity who has broken that law, who has broken that code of conduct, right? So that's why when you see states and you look at when you look at cases, the case always reads the people of California versus O.J. Simpson or the state of North Carolina versus Brenton Boyce. What that is saying is you have violated this law that's agreed upon by everybody else, or you're accused of violating this law. Now we're going to bring you to court, and it's us representing all of society versus you. So you have to come to court to explain why you did it, either as a justification or an excuse for why you did it, or you're coming to court to say you didn't do it. So that's what it is. That's the who versus who. It's essentially us versus you, or versus individuals. Everybody else, society or the community versus you. Um, so then I had another question. What's at stake in criminal law? What's at stake is life, liberty, and monetary interest. You can be fined, right? Things can be taken from you. Um, so if it's a very serious crime, like capital murder, your life can be taken. You can be put on death row. Capital punishment can be imposed. So that's very important. Or your liberty can be taken. That means we can now give you adult timeout, where you now have to go here and be told where to go. You're now, as I said, via the 13th Amendment, you are now a slave to the government, and we can sell you out and parcel you out to the highest bidder, but you're a slave for this amount of time. If you get 10 years in prison, that means now for 10 years, you are the property of the state or the federal government, whatever government is prosecuting, whatever sector of the government is prosecuting you. So there's liberty that's at stake, and of course you can be fined, and 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 money can be taken, and sometimes things can be taken from you as well. So the stakes are pretty high in criminal law, and that gives rise to the very high burden of proof. In criminal law, who has the burden of proof? The prosecution. The prosecution is the represents the interests of the people or the community, right? So they are the solicitors of the people, of the people's interests. They're there to protect the interests of the people. They're also there to make sure justice is served, right? In representing the people, they also represent the defendant, even though they don't directly represent him against themselves. But when I say represent the defendant, a lot of times um, the first person that, or the first entity that looks out for the best interest of a defendant, especially if a defendant doesn't yet have an attorney, is the prosecution. The prosecution, they want to get, if they're going to get a conviction, it's their job to make sure the conviction is just and it's right, and they haven't cheated anyone. Um, so that's what we call justice. So is there so that's their first job, and they also have the burden of proving if they're going to take this person to trial or fully prosecute them. They have the burden of proving guilt, and that burden of proof is beyond a reasonable doubt. So what that means is the prosecution that represents the interests of the state. That means having the burden means the only reason we're here is because you have to prove that I did what you said I did. And you have the burden of proving it. That's what we call the burden of proof. That means you're now carrying the weight, and you have to convince a jury or in a bench trial, a judge, that this person is actually guilty of this crime. The defendant has no burden at this point, at least not in the beginning, depending on what type of defenses they may bring up. They can sometimes have burdens, but definitely not a burden of proof of guilt or innocence in the case. The defendant's only job is to be there and be square. They really don't even have the burden. Defendant doesn't really have the burden of even defending himself, his or herself. They can just be there. So the burden rests solely upon the prosecution, and that burden of proof is very high. The burden of proof rests upon the representative of the people or the prosecution to prove guilt beyond a reasonable doubt. So the burden of proof is beyond a reasonable doubt. what does that mean? So in North Carolina, pattern jury instructions, beyond a reasonable doubt is defined as when a finder of fact, that the finder of fact is the person that's determining guilt or innocence. So that's the jury or the judge in certain cases. Depending, it may be the judge just determining guilt on a bench trial, and a jury trial is the jury. But the finder of fact must be fully satisfied and entirely convinced of a defendant's guilt. So that means I must be fully satisfied based upon the evidence given, and I must be entirely convinced by that evidence that this person did it. Two main words: fully, entirely. Um, a cup is only entirely full when it's full. There's no more room. If you pour anything else in, it's gonna overflow. So if we were to give a mathematical equivalent of beyond a reasonable doubt, that's that fully satisfied and entirely convinced, I would say between 99.9% and 100%, pretty much 100%. We always give a little bit of room, that 99.9, to make 99.9 to 100%. So it must be beyond, and it's not beyond a shadow of a doubt, but beyond reasonable doubt. So that reasonable doubt is nothing more than doubt based upon reason. Um, so what that means is, there's anything that's based upon reason that makes you believe that I don't know if this person did this, or it's possible that he didn't do it. That means that it's not been proven beyond a reasonable doubt. So that means there's no reasonable doubt in the mind of the juror that this person did this crime. There's no doubt, no reasonable doubt. Now, and when we say reasonable doubt, that's doubt based upon reason. It means the doubt itself has to make sense as well. If there's doubt, but that doubt isn't based upon reason, like, oh, well, I don't think that person did it because aliens could have come and did it. I think aliens did it. That is doubt, but it's not reasonable doubt. So the doubt has to be based upon reason as well. Um, so limitations of criminal law. We talked a little bit about this before, when we talked about creating laws in chapter 2, when we talked about the 14th Amendment equal protection process, when we talked about laws also having laws. So laws, even criminal laws, have to be constitutional. Just because it's law doesn't mean it's going to be good law and going to be accepted and going to be constitutional. Laws must first and foremost be clearly written as to give citizens notice of what acts are illegal and notice of the punishment. Laws that fail to give such notice are usually deemed violative of due process and unconstitutional. So what that means is, I need to be able to look at the law, and based upon the way the law is written, it tells me exactly what I can and can't do, what's legal and what's illegal. So if a law is not clear on that, then that's not cool. That means I'm going out here, I have no direction, and that essentially means now law enforcement, the people that are there to enforce these laws, now can kind of determine what the law is as they go, and that's never the safe thing. Um, First, we have the overbreath doctrine. So in this chapter, when we talk about limitations of criminal law, we talk about how a law is written on its face. So the overbreath doctrine: a law is unconstitutional when it fails to narrowly define the specific behavior and actions that are restricted or illegal. So if a law is unclear about what you can and can't do, then it's not it's what we call overbreath. That means it's because it doesn't narrowly define it. It makes a whole bunch of things that could be allowed also, that it makes them also illegal. They can also be deemed illegal by law enforcement. Then you also have, it kind of sounds the same, but you also have the void for vagueness doctrine. So you have overbreath and you have vagueness, two things. Vagueness. A law is void if it fails to clearly define the act prohibited and the appropriate punishment. So we need to know what is prohibited by this law, what I can and can't do, and what the punishment is. An example of voidness. An example of vagueness and overbreathness would be a motor vehicle law that states that you're not to drive too fast in this area. The problem is it doesn't narrowly define what too fast is. So if the law states on its face you can't drive too fast in Greensboro, what is too fast? It's all relative. Is too fast 45 miles per hour or faster? Is too fast 100 miles per hour? What is too fast? So that in and of itself would be vague and over breath. Because what happens now is you have law enforcement who are out here enforcing the laws, and now instead of having definite standards upon which to enforce, they're now in a position where they're creating the standards as they enforce them. So we call that creating unfettered police discretion. So the police get to not only determine how to enforce the law, but they also get to define the law they enforce. So the police are now judges. The police now turn into the judiciary and law enforcement in one person, right? And that's unfair. It's unconstitutional. So if you have a better law in this motor vehicle law hypothetical would be the speed limit is 35 miles per hour. That is definite. That means when I'm driving my car, once I get over 35 miles per hour, I am breaking the law. Not just driving too fast, but having definite speed limits is not void for vagueness. That is not vague and it's not over breath. It tells me what I can and can't do, and it tells me how I can be punished. So if it's a moving violation, you can be fined, and it tells me the punishment. That's what laws are supposed to do. They're supposed to tell us. They're supposed to be specific about telling us what we can and can't do. And if we do go outside those parameters, what's going to be the punishment? Now, when laws are codified or on the books, that constitutes notice. So we don't walk around as individuals knowing every law, right? But we walk around with the ability, just like everyone else, to get to know what's right and what's wrong and what the law is, because the law is made public and is codified in statutes and codes. So that's how that's how we're put on notice of laws. So when laws are codified or put on the books, that constitutes the notice that is required. Not reading the law or not knowing it is never an excuse for committing a criminal offense. So what that means is ignorance of the law, or I didn't know it was illegal, is never going to be it can never be used as a viable defense in criminal law. When laws are overbreath or vague, they lack enforceable standards and therefore leave room for unfettered discretion of law enforcement officers while enforcing the laws. As I said before, that's cops making the law while they're enforcing the law. So now we're going to talk about that's like the beginning stages of what a law is, what a crime is, and the limitations, the statutory limitations, or the hurdles, or what it takes to be a viable criminal law. Now we're going to delve into the elements of a crime. What is a crime made up of? Like, so when we're defining crimes and crimes are on the books, what is a crime? Or, what is the corpus delicti, or the body of a crime, right? So crimes are made of four primary things. There's an actus reus, and that is that's Latin, but so actus reus essentially means an act. Then you have the mens rea, mens meaning mental. So you have an act coupled with a mental state. And then you have concurrence, which means that act and that mental state have to be at the same time. And then you have causation, which means that act and that act you took and that mental state caused a certain harm, and that they're actually the cause of the harm. Now, some crimes don't necessarily have a harm to it, right? Prostitution, but they're still essentially a harm to, I guess, society, right? That's why they, it's those are what we call victimless crimes. But so let's talk first about actus reus. Actus reus is the criminal act, and that act must be a voluntary act. So it must be a voluntary act or a voluntary omission or failure to act where there is a legal or contractual duty to act. What's that mean? What that means is, so if I'm committing murder by stabbing someone in the chest, my criminal act is picking up a knife and actually committing the stabbing, killing someone, right? But a murder, a murder or a homicide. I'm sorry, let's murder specific. Let's be less specific. A homicide. It could also be a homicide in the position where I was supposed to do something, but I didn't. Let's say if I'm a lifeguard. As a lifeguard, I have a contractual duty, an illegal duty to try to save people that are in peril in the water, right? So if we're at the city pool and I'm the lifeguard and I see that a person is drowning. This person's over here is drowning. I see them going under and I see it and I choose to ignore it and I say I don't like that person anyway. Screw them, let them die. That omission, even though it's not an actual action, that failure to act is an action. So me failing to act can also be considered actus reus. So either way it goes, whether there's an actual act taking, like me stabbing someone, or me failing to jump off of my lifeguard post and jumping in the water to try to save someone, either way it goes, it has to be voluntarily and knowing. So let's say the voluntary act. Voluntary means you're doing it at your own volition. You're not hypnotized. You're not sleepwalking. You know what you're doing. Same things with omission. It has to be a voluntary omission. What's that mean? If I'm a lifeguard on post and I'm not paying attention, I turn around, I'm talking to somebody, and I don't know that someone's drowning, that's not a voluntary omission. In other words, I'm not failing to do my job and get in there and go save a person because on purpose, or I'm not doing it voluntarily. My mind is somewhere else, and I don't know. I don't see what's going on. So in that situation, there wouldn't be any criminal responsibility or liability. Now, but if I see this person is drowning and I voluntarily choose not to act, that is the voluntary omission. So it's a voluntary act or a voluntary omission. That is the actus reus of a crime. The mens rea. Mens rea means guilty mind. Guilty mind or mental state that must accompany a criminal act. So at the time that I commit the actus reus, and that's either the voluntary act or the voluntary omission, I must have had a guilty mind, meaning I must have done it intentionally, knowingly, recklessly, or negligently. So, I'll give you a definition of a crime. First degree murder. First degree murder is defined as the intentional killing of another person with malice of forethought and premeditation and deliberation. What's that mean? Or with premeditation and deliberation. First degree murder means I came there with the purpose, and at the time I did what I did to kill the person, I did it with the purpose of killing him. It was intentional. And when we say premeditation and deliberation, I planned it and I premeditated. In other words, I didn't just walk up on this person that made me mad and I killed him on purpose. I knew I was gonna kill this person before I did it. I planned it. I said, well, I'm gonna meet him at their house. I'm gonna hide behind the bushes. I'm gonna jump out. That is that premeditation and deliberation that makes it first degree murder. So the actus reus is the act that I take to kill the person. Shooting the person with a gun, stabbing the person with a knife. That's the act. The mental state or the mens rea has to be simultaneous to the act. That means at the time I stabbed the person, I did it intentionally. I did it on purpose. I did it knowing what was going on. That is the mental state. So it's an act, it's an illegal act that's taken coupled with simultaneously. That's what concurrence means. Simultaneously with a mental state. Um, so with the mens rea, the model penal code essentially gives us four main levels of mens rea. And normally, when you talk about a body of crime or a certain type of subject matter of crimes, let's say a homicide, right? So homicide essentially means the killing of a human being by another human being, the unlawful killing of another human being by another human being. That's homicide. You have differing levels of homicide, though. You have first degree murder. Um, you have first degree felony murder. So with first degree murder, I'll just define that for you, right? The unlawful killing of another. The unlawful killing of another person with premeditation and deliberation. The intentional unlawful killing of another person with premeditation and deliberation. So you have the killing of another, and then you have intentional with premeditation and deliberation. That's like the mens rea, and then the premeditation and deliberation is like the mens rea plus of first degree murder. Second degree murder, which is a step down, is the intentional unlawful killing of another person. What that means is you killed a person on purpose and you meant to do it, but you didn't plan it before you did it, essentially. Um, a fight broke out, something happened, you lost it and killed a person. And you did it, and what you did to him was on purpose. Um, but it wasn't something you planned out. You didn't go get a gun. You didn't write out plans. You didn't wait for them, lie and wait for them to get there. So you see the difference. Then you go down to your involuntary manslaughters, where you do something recklessly, or you do something knowingly, or you do something and it causes the death of a person. The difference in levels of punishment from first degree murder all the way down to negligent homicide is based on the mens rea, that guilty mind. So it's not just about what you did; it's the mindset you had when you did it. Did you do it on purpose? Did you do it knowingly? Did you do it recklessly, or did you do it negligently? So the model penal code talks about four main levels, and the level of importance or seriousness of your punishment is going to be based upon um, the level of mens rea you had. So especially with homicide. Homicide is what we call a result crime, which means that a specific harm happened. So homicide means that a human must have been killed by your actions or inactions. So that's what we call a result crime. So we'll talk more about that when we get to causation as well. But there are four levels of mens rea. That's intentional or on purpose. That means you do something with intent and you did it on purpose. Then you have a step below that, and a step below also in seriousness is knowingly. When you do something not necessarily intentional, but you know or have reason to know that a certain harm is going to result from you doing this. Then under knowingly, you have recklessly. Recklessly is when you know that there's a risk or very high risk, but you proceed anyway, and someone gets hurt as a result of you saying, screw it, I don't care about the risk, I'm going to proceed anyway. That's recklessness. Then under that, the lowest of them all is negligence. Negligence is when there is a risk, but you fail to realize it. Either you're too dumb to see it, or you're not paying attention, and someone gets hurt because you were not on guard and you were not being careful. So you see how the mens rea can determine how serious your crime is. So so even though homicides all end in someone dying, all the homicides aren't the same, because anyone that commits a first degree or felony first degree murder, um, or anyone that commits a negligent homicide, like let's say death by motor vehicle, persons being negligent, they're drinking while driving, run off the road and kill someone, that person should be punished the same as a person that commits a first degree murder, where they plan it out, they lie in wait, and they go and kill someone. So the difference in punishment is based upon the mens rea that you had for the crime you committed. So that's why mens reas are so important. So remember those four mens reas. You have intentional, or on purpose. You have knowingly, you have recklessly, and you have negligently. Um, and let me define recklessly and negligently again, so because sometimes they sound a little bit alike. Recklessly is knowing of a substantial risk. Now, knowingly means you know something's going to happen and you proceed anyway. Recklessly is knowing that there's a risk. In other words, this is a highly risky thing, but I don't care about the outcome. I'm going to do it anyway. So it's knowing of a substantial risk, but proceeding anyway without regard for that risk. That's recklessly. Negligently is failing to realize an obvious risk. Like if you would have had your eyes open and been paying attention, you would have seen that something could happen, but you didn't. You weren't paying attention. Or proceeding without caution for a risk. So you're proceeding without caution, not paying attention to the fact that something bad could happen. So it's like proceeding before looking where you're going, or proceeding while intoxicated. So those are the 4 levels, and as you see, as you up at the top, you have intentional, which is the most serious, all the way down to the bottom, which is negligently, which is the least serious. Now the next, what do you call it? One moment. The next, I guess, part of the corpus delicti, body of a crime or element of crime, is concurrence. Concurrence means the simultaneous union of the criminal act and the intent. What that means is both the act and the intent must exist simultaneously. An intent without an act is not a crime at all. So I may want someone to die. I might be like, oh, I want them to die. But if I don't take an act in furtherance of killing that person, it's not a crime, right? If I take an act and someone dies, but I didn't do it intentionally, then or there's no intent, or there's no mens rea, then that's also not a crime. Or it could be a crime, or it would be or maybe a lesser crime because my mens rea isn't intentional and maybe all the way down at negligence. So concurrence means that the guilty mind and the act must exist at the same time in the same space. Then we have causation. When we talk about causation, we talk about a harm that. So the reason that this law is a crime, or that this act is a crime, is that society sees that there's a harm that they want to prevent. Homicide is a crime because we want to prevent people from getting killed by other people, right? There's a harm we're trying to keep from happening. So you have your actus reus, your act with the mental state at the same time with concurrence, and then you have a harm that is caused. In a crime like a homicide, where that harm is a death, we also have to think about whether or not the act was actually the cause of the death. So causation is very important. So the criminal act or the harm must be, the criminal act must be the cause of the prescribed harm. So in homicide cases, the harm is death, right? So before we can prosecute someone for taking an act that caused the death of someone, we have to make certain that that action is actually the cause of the death. So causation is very important. So you have 2 levels of cause. And both of them have to be answered in the affirmative for a person to actually be the cause of a death or of a harm. So you have factual cause. Factual cause is what we call the but-for cause. What that means is, but for the actor's conduct or their actions, the harm would not have occurred at all. In other words, we wouldn't be here if you didn't do this. That's what but for means. Is essentially the initial act that sets forth a series of acts or occurrences that lead to a harm. So the book says the initial act that sets a series of acts, occurrences in motion that leads to a harm. So that's the but for. That means we're only here because you did that. Now, then after that, we have something called legal cause. This was the next question. So when you're trying to figure out whether someone is the cause, you have to ask yourself first, are they the but-for cause? If they're not the but-for cause, end it. They're not the cause. They're not guilty, right? But if they are, and you say they are the but-for cause, then you don't end it there. You have to ask another question. You have to say, okay, since they are the but-for cause, now the question is, are they also the legal cause? Second question, legal cause. So the two levels of causation. So it's but for cause or cause in fact, and then it's legal cause or proximate cause. So when we say legal and proximate cause, those are the same thing. Um, legal cause or proximate cause is when there are no intervening acts or occurrences outside of the knowledge and foreseeability of the actor that can cut the causal chain between the factual cause and the harm. Let's say, for instance, if I'm driving a car and there's a motorist beside me and I intentionally say I want to knock that person off the road and hurt them, so I swerve and knock and bump their car and they drive off into the ravine and it goes all the way down and they die in a fiery death, right? In that situation, I was the but for cause. I had there was a criminal act with the mens rea. I did it intentionally. And I was the but for cause, and there was no intervening cause. So in other words, my act directly led to. But for my actions and intentionally swerving and knocking them off the road, um, they would be alive. Then two, the second question, there was also no intervening cause or anything else that happened that led to their death. So that means I'm both the but for or legal cause. I'm both the but for or cause in fact, and I'm the legal cause or proximate cause. Now let's change the narrative. Let's say I intentionally bump someone to push them off the road as they're driving, and they go off and land in the ditch, and their car is now disabled. I keep driving. I don't care. They don't die, but they're on the side of the road. They get out of their car, and it's the middle of the woods. It's a wooded area. It's in the wilderness, and they get out of the car, and all of a sudden, a bear comes out of the forest and rips their head off and eats them. In that situation, yes, I am the but for cause. But for me knocking them off the road, they would have never been put in that position where a bear could chew their head off, right? But I'm not the legal approximate cause because there's an intervening act or occurrence that happened that actually caused their death. So in that situation, the bear killed them. I didn't. But for my act, I put them in that position, but I can't be the legal cause of the harm because an intervening act happened. And not only is it intervening, but it has to be unforeseeable. So it's intervening and unforeseeable. And it break. That's what we say. It breaks the causal chain between the factual cause or the but-for cause and the harm. So yes, I was the but-for cause of putting them on the side of the road, but once something unforeseeable happened that caused their death, that cuts the chain of causation. So that means I'm not the but for and the proximate cause, so I'm not the cause at all. So something intervening and an intervening action, or intervening act took place or occurrence took place that was unforeseeable. Now, some things can intervene that are actually foreseeable, and if it's foreseeable based upon what I put them the peril I put them in, then I can still be both the but for and proximate cause. So let's change the hypothetical. I swerve off the road and I purposely make these people swerve off the road. They hit an embankment, but they don't die right away. Go to the hospital, and they're at the hospital. They get to the hospital. They're living, and while they're in the hospital, um, they start to lose blood and they're having internal bleeding, and the doctor goes in and makes a mistake during surgery that causes the death. Um, Now that is a intervening event, right? But it's all foreseeable because if I'm causing that type of harm, running somebody off the road, in all likelihood, they're going to need medical treatment. And as long as that medical treatment isn't beyond some type of foreseeable scope, um, it's foreseeable that they're going to need surgery or need some type of to be mended. And it's foreseeable that a minor mistake that goes along that is in the chain of foreseeability could happen that could cause that person's death. So in that situation, I am both the but for and proximate cause, and I'm the cause of death. Um, there's also another situation. Let's change the narrative again. Let's say run them off the road, hit an embankment. They don't die right away. Take them to the hospital. They get to the hospital, and the doctors not only make a minor mistake or mess up in surgery, but they the person has an injury to their chest, but they make a grave mistake in their, I guess, on the orders or the surgical orders. They mix them up and they actually do surgery on the brain and kill the person. In that situation, um medical malpractice that is that egregious is never foreseeable. If it's something standard and something having to do with what their actual injury was, and the surgery just goes bad, or there's minor malpractice that goes with what they were trying to do to fix the person, then that is totally foreseeable. If it's something that's like, okay, you did the wrong surgery on the wrong body part, the person wasn't there for that. Yes, I put him in that situation, but your grievous medical malpractice is actually the intervening cause of the death and not just me running them off the side of the road. So the different situations that can kind of be a toss up. So um, that is it. So then we talk about harm. So those are the four main things. The four main, you have actus reus, a couple. You have actus reus in concurrence with the mens rea, and there must, and then your act must be the actual, it must be the cause. And then when I say cause, that means uh fact, cause and fact, and legal cause of a harm. And then so the last element is harm. Harm is the result of the illegal act and usually the reason why the act was illegal in the first place, to avoid specified harm. A harm can be physical injury, and that is to say, injuries resulting from an assault. And harm can also be economic, that is to say, the value of property that was taken or destroyed. So, let's say in the case of larceny, larceny is the unconsented and transitory taking and carrying away the personal property of another person. So if I come up to you and pick your pocket and take your wallet, I do it on purpose. My the actus reus is me taking, um, and the mens rea is intentional. I did it intentionally and with the intent to permanently deprive you of it. So not only did I intentionally take it, but I took it so that you would never get it again. I was gonna Now it's mine. I'm taking your money. Your wallet is mine. That is the mens rea, and they have to be concurrent at the same time. Um, and the harm is the fact that you've now been deprived of your property interest in your wallet, what you have. I've now taken something from you. So I was the cause, both legal and proximate, of you now not having a wallet. So a harm can also be a nuisance. So that means it may not be a physical injury, and it may not be a loss of property, but sometimes harms can be a nuisance, or negative impact. Nuisance meaning it has a negative impact on the quality of life and quiet enjoyment of a community. That means like when a person disturbs the peace or incites a riot. So like with city ordinances, like with noise ordinances, if there's a city ordinance that says you can't turn up your music over certain uh, volume level, a decibel level, um, then what you're doing when you intentionally, when you turn your music up and you're driving around with the music up, you're now affecting everyone else's quiet enjoyment because the thing is no one else wants to hear it, right? So even with stuff like prostitution, noise ordinances and prostitution are what they call the victimless crimes, because there's really no victim. They say the victim is society as a whole. Um, with prostitution, there are only two people involved: the person is this buying and the person is selling. Um, so both people have an interest to gain, and both people are there voluntarily. One person trying to get something, and the other person is also trying to get something. So literally in that situation, who is the victim? There is no victim, but the victim is society as a whole, because society had, in a society where prostitution is actually illegal. It's not illegal everywhere, but if society if it's illegal in this state, that means according to the laws and the standards of our community in this state, we don't want that type of stuff going on. It falls below a certain I guess a certain let me see, community standard. So the victim is the community as a whole. You've fallen below what we want to have done in our place. Even though there's not any direct victim, nobody got punched in the face, nobody got anything taken, but the victim becomes society as a whole. And there's a lot of times there's a lot of questions on whether we should enforce laws like that or even have them. So now we've talked about those elements. Now, what about the type of law where there is no mens rea? So there are a special classification of criminal laws where there is no mental state that is required. These are called strict liability crimes. And strict liability essentially means liability without fault. So that means you didn't have to do it on purpose, you didn't have to do it knowingly, you didn't have to do it recklessly, and you didn't have to do it negligently. You're essentially being punished just because it happened. Now, these are crimes that do not have a mens rea within the verbiage of their definition, and they punish conduct and the resultant harm simply because it happened, regardless of the intent. Um, these are usually modern codified and statutory laws. Um, the first of which would be like statutory rape. And statutory rape is just that. It's statutory, meaning that based upon where you are, the code of law in that state or that jurisdiction, the statute's going to tell you what it is. So statutory rape is essentially having sex with someone below that statutorily specified age of consent. So, and you have to be a certain amount of years older than them as well. But all that is explained in the statute. It doesn't matter why you did it. It doesn't matter that you knew or you didn't know. There was intentional or reckless. It's just that is the type of harm that is so important. They want to prevent it so bad that no matter why you did it, it's bad that you did it, and you got to be punished for it. That's statutory rape. So in North Carolina, the age of consent, sexual consent is 16. So if a person is less than 16 years of age, and the other person that's having sex with them is 4 or more years older than them, meaning that if this person is 15 and the person having sex with them is 22, that is technically statutory rape. It is, when that is definitely not even technically, that is statutory rape. So it doesn't matter that the person didn't know. Maybe the young lady, the way she was dressed or the way her body was built, she looked older than she was. So she looked like a grown woman. I had sex with her, um, but she was only 15, meaning it was legal for you to do it. And based upon the strict liability of statutory rape statutes, it is what it is. You're guilty of statutory rape. You didn't have to do it purposely. Um, Now, of course, in certain situations where the I guess alleged victim in the case held themselves out to be older than they were, that still doesn't mean you're not technically guilty of statutory rape, but it can affect how the prosecutor decides to prosecute the case or whether to prosecute it at all. So the prosecutor still has discretion, even though that's a strict liability offense, meaning you're in trouble just because it happened. It doesn't matter whether you knew or not. Um, there is fairness in it because the prosecution can look at these things on a case by case basis and determine whether or not they're going to prosecute the case. So, and it's actually happened in real life cases that I know about. I don't do sex offenses, but I've known about cases in the Guilford County Courthouse where there was a young lady or a man above a certain age that had sex with a woman that was below a certain age, but that woman that was below a certain age was holding herself out by dressing like she was older, lying to the person the whole time, and in certain situations they even present a fake ID, trying to lead this person on to believe that they're older than they are. So in those situations, if the prosecutor is fair, they're going to look at it and say, whoa, I mean, this person was bamboozled by this person, even though this person's only 14 years old. They were out here saying they were 18 and, showing off a college ID or showing off this and that, holding themselves out, even though they were lying. Even though technically this person could be, could be charged with statutory rape, because of the facts, looking at it on a case by case basis and what the alleged victim was doing, we're not going to prosecute it. So you see how prosecutorial, and when we talk about the role of prosecutor, we'll talk about that later on about what prosecutors have the right and have the discretion to do. So that's strict liability. Other strict liability types of crimes would be environmental regulation violations. So let's say if you have a business and there's a regulation that says you can't emit a certain amount of smoke. It doesn't matter if you did it on purpose or not. If it happened, it happened. Same thing with food and drug safety. When the health inspector comes and inspects a restaurant, that is strict liability. You got rats, so you have something that's making you fall below code. It doesn't matter if you did it on purpose. It happened, so you're in trouble, or you're gonna get fined, or whatever. That's same thing with workplace safety and stuff like that. So, but I just want you to remember most strict liability laws are based in either administrative codified law, administrative regulation law and codes, or in statutory codes, meaning it's specifically and explicitly stated in a statute. So that's strict liability crimes. Those are crimes that do not have a mens rea. So there's some crimes that's the exception to the definition, to the elements of crime. There's some crimes that do not require mens rea. You get in trouble just because it happened and you did it. Now we have another class of crimes called the inchoate crimes. A crime that is inchoate crimes, or called the incomplete crimes. A crime that is incomplete or that happens in the preparation of another crime. So you have three main inchoate crimes. You have attempt, you have solicitation, and you have conspiracy. Let's first start with attempt. Um, the attempt as a crime was created in an effort to punish those who try but fail to commit a crime, where the failure is not the result of a voluntary withdrawal from the intent to commit the crime. Let's say if I'm going to kill somebody and I got my gun, I got my bullets, I'm going to their house, I'm hiding behind the bushes, waiting on them to get there so I can jump out and kill them. And while I'm there behind the bushes, I say, you know what? I shouldn't kill this person, man. They need to live, man. I'm wrong for this. And I walk away from the crime. Have I actually done enough to commit the attempt? More than likely, yeah. But am I excused from it, or is that will I be charged with it if I walk away on my own volition? I could use that as a defense. Now if the person comes and I jump out and I shoot at them and I miss, or the gun jams as I'm shooting, I attempted, but something else intervened that made me not be able to complete the crime. So I'm still guilty of an attempt. Um, So let's say a try to commit a crime where the elements are there is an attempt or a try to commit a crime where there are significant acts taken in furtherance or in pursuance of the intended crime, and there is a failure to complete the crime that's not due to any voluntary withdrawal from the crime. So if you voluntarily say I don't want to do it anymore, then it's not an attempt. You walked away from it. But let's say you did try, you tried everything you did, and some type of factual impossibility or something happened, and it didn't happen. Let's say the person never showed up, so you were lying and wait for them to get there, but they never showed up. You did not kill that person because you decided not to commit the crime. You didn't kill that person because they didn't show up for you to kill them. So that can still be an attempt. Um, so then you have next. So that's an attempt, and the attempt to commit a crime is a crime in and of itself. So normally, like I said, is usually a failed attempt at a crime. So you can't be charged with attempted murder and murder. If you kill the person, it's murder. If you try to kill the person and you don't do it and you fail, then you can get charged with attempting to murder the person. So the next crime is solicitation. Solicitation is asking or coercing another person to commit a crime with the intent that the other person commit the crime. So the act. So let's talk about. Let me go back to attempt. The actus reus of attempt is that you tried or you took steps in completing the crime and trying to complete the crime, and the intent is that you did so with the intent that the crime happened. Um, and then it also must be coupled with significant steps in committing the crime. So you took significant steps or got significantly close to committing the crime. Solicitation is asking or coercing. That's the act. The actus reus is asking or coercing another person to commit a crime. And the intent is that you did so with the intent that this person would actually commit the crime. So that's what that is. So the act is that you say, hey, can you kill my wife for me? I got 10,000. I just need you to do it. And I know there's a show out. What's that called? The Tiger King, where this guy is this person that he's hated for a long time. They've been they're kind of on the opposite sides of the issue of animals and keeping exotic cats. And this man hates this woman because she believes, and she does the same thing. So they go back and forth in public. He leaves nasty messages on face. He makes these nasty posts on Facebook and makes it public that he hates this woman's guts, and he wishes that she was dead. So in the show, there's an accusation that he solicited someone to murder her. When there's all types of stuff out there showing that they don't like each other. So just because he doesn't like each other and he says he wishes this bee would die, doesn't mean that he's gone as far as to solicit someone or try to pay someone to commit the crime. Um, so so of course there have to be significant steps in furtherance. So it's not just that you ask the person to actually there don't have to be significant steps. All it has to be is you solicited the person, and that significant step is that you tried to push them or tried to maybe trade off some type of consideration to get them to try to commit the crime. Um, so joking does not constitute solicitation. So if you say something in jest, like "Oh, I wish that chick was dead," ha ha ha, there's no solicitation. Joking does not constitute solicitation because there's no actual intent that a crime actually take place. And that was kind of the defense in the Tiger King thing. He made funny videos where he got a person that looked like her. So it was a lot of slander and bad ill will stuff that went back and forth. A lot of it in jest and in joking because he really didn't like the lady. But I think to say that goes as far as to say that he is guilty of solicitation. It was a little bit of a stretch. So now let's go to conspiracy. Conspiracy is an agreement between two or more people to commit a crime, coupled with significant acts taken in pursuance of the intended crime. So me and two more people are sitting down planning the bank robbery. We case the place. We say we're gonna do a robbery on this date. Here are the floor plans. Let's get the guns and stuff like that. That is a conspiracy. I don't have to finish the crime out for it to be a conspiracy. So we don't actually have to go through and commit the bank robbery for it to be a conspiracy. Now, if we do commit the bank robbery, go get out with the cash and then get arrested later, we can be charged with both the conspiracy and the crime itself. Same thing with solicitation. If I solicit someone to kill someone, I could be charged with um, solicitation and be charged in the murder, right? Um, Attempt is different, right? Attempt is different from both of the other two because with attempt, either you committed a crime or you didn't. If attempt is a failed commission of a crime, right? So if I follow through and actually commit the crime has been done. There's no more attempting. But solicitation and conspiracy are different. So there's an agreement between two or more people, and then there have to be significant acts or steps that take place pursuant to the intended crime. So it's not just that we sit there and say, let's rob a bank. Yeah, we should rob a bank. And we get up from the table and do nothing in furtherance of robbing the bank, then it's not a conspiracy. If we say, hey, let's rob a bank, and then we say, well, I'll get the guns, I'll do this, I'll go get the mask, and we all go do this stuff, and I'll go get a map of the bank, and so we can map the floor and where we're going to stand. At that point, it is a conspiracy because we've done things, we've taken significant steps towards planning and making the crime happen. So that's conspiracy. Two types of conspiracies I'm talking about. One is the chain conspiracy, and the other is what we call the wheel or pinwheel conspiracy. Um, the chain conspiracy means that each link is connected, it must be connected for the crime to take place. This is normally in the drug game. Those drug conspiracies have very long chains. They have a chain that starts out with the supplier, where the drugs come from. You have the person that moves it from the supplier to the distribution person in a certain area. Then this distribution person gets the drugs out to everyone else, and they do what they do. So you have all these chains that are linked together in the commission of one crime. If one link is broken, that actually ends the conspiracy. So each link is important. That's why it's called a chain. So the drug dealer on the street can't sell drugs if the supplier way back at the other end of the chain can't supply the drugs. So that's a chain conspiracy. Then we have the wheel conspiracy or the pinwheel conspiracy. If anyone's ever seen a wheel or a tire, you have the round circle that's the tire, and then you have the spokes that could reach out from the circle to the middle to connect the tire to whatever is holding the tire when it's rolling. What that means is that you have a wheel and you have the different spokes that are connected to the wheel. If you take one spoke out of the wheel, it doesn't mean the wheel is not going to keep going. So with a chain, everyone's connected. Every step matters. With a pinwheel conspiracy, if one person's out, the crime can still happen. So that's all that means. Usually, those are sometimes like in white collar crimes and stuff like that, where and sometimes conspiracies can be so what would I say? They can be so thinking of the word not can't think of the word right now. I'm kind of at a loss. But they can be so crazy, and this is not the word I wanted to use, that there are so many parts of it, right? So even in a chain conspiracy can be a chain that's a part of a pinwheel conspiracy. So if anyone watches the show Ozark, um, of course you have a drug lord in Mexico that provides drugs, and the drugs move in a chain from person to person, all the way to the distributor, all the way to the street. But then you have other people that aren't connected in the chain, but they're helping the conspiracy because they're part of the pinwheel conspiracy. There are people that are cleaning the money for the drug dealer, like in the show Ozark. Um, the person that's laundering the money, so does not connect. This person never touches a drug, never passes a drug, but they're a part of the pinwheel because they're helping to keep um the conspiracy going, even though they're not connected in any other part. So that's just it. So some situations the wheel and the chain conspiracy can kind of be a part of the same thing. So, but those are conspiracies. Then you have parties to crime. Who can be charged with a crime? Essentially, anyone that takes part in the crime can be charged with a crime. Um, those who knowingly assist others in the commission of crime may also be held responsible. At common law, you had what we call principals and it was principals and accessories, and we still kind of say principals now. A principal is the main actor in the commission of a crime. Accessories or parties to a crime, whether main actors or just mere assisters. So back in the day, you had principals and you had accessories. Now, in more modern law jurisdictions, everyone's an accessory. It just depends on where you are as an accessory. You have accomplices. I'm sorry, you have accomplices and you have accessories. Um, so accomplices are the people that are really a part of the meat of the crime, and accessories. An accessory is a person that assists either before, during, or after. So you have accessories before the fact. That's one who helps prepare the crime, such as providing a weapon or providing a map. You have accessories during the fact, and these are usually accomplices that are part of doing the crime. That might be the getaway driver. While you're committing the crime, the getaway driver's waiting um, for you to come out so to drive off. Then you have accessories after the fact. Um, that's one who helps after the crime has taken place to avoid arrest or apprehension or obstruct an investigation by disposing of evidence. So they're essentially trying to make it harder for this person to be apprehended or be arrested or be brought to justice. That's an accessory after the fact. So those are the parties of crime. You have at common law, you have principals. In modern law, you have accomplices and accessories. Um, Now, what are the defenses? If you're charged with a crime, what we're going to talk about the two classes of defenses to crimes. Uh, First defense, and the major defense is alibi. That's I didn't do it. I wasn't there. It wasn't me. Normally, with this, you might want to walk in and have evidence where someone can show that, hey, he wasn't there. He was actually out of town. In those situations, the defendant would have the burden of proving the alibi. So if you have an alibi, you might want to put forth evidence that helps show that you were somewhere else. Um, then you also have two other types of defenses. You have justifications and you have excuses. Justification defenses first. Justification essentially means, yes, I did it. I committed the act, but I was justified in doing so, so I should not be punished. This is the classic case of self-defense and defense of others. Um, and what self-defense or defense of others means is one can use only the level of force that is proportionate to the force that is threatened against them or someone else in order to protect themselves or another person from bodily harm. So if someone's trying to smack me or smack my wife, I can't protect myself or protect her by pulling the gun out and shooting them. Um, what that means is the force I use to protect myself or someone else must be proportionate to the force that's being used to threaten me or someone else. So that's what that means. So that's the law of self defense. You can never use deadly force to protect personal property interests. So if someone's stealing your car, you can't shoot them. If someone's breaking in your house, you don't have to really, take the time to think about why they're coming in. You can assume that they're coming in your house to do you harm, and you can use deadly force in that situation. You have the retreat doctrine. In some states, they have the retreat doctrine. Some jurisdictions require that a person attempt to escape harm before resorting to deadly force. Stand your ground is the opposite of that. What that means is if someone uh, tries to use force on you, you don't have to try to retreat at all before you use any type of force. You can stand your ground and protect yourself. Um, then you have the castle doctrine that says you can use deadly force to protect oneself and one's home without having to try to retreat. So in my house, I'm in my house. Why should I have to try to leave to protect myself? I'm here at home. You coming in, presumably to harm me. I can use deadly force right away. So you have self defense and defense of others as a justification. You also have consent. And that, what you're saying is, hey, I did hit the person, but I had permission to. We were in the middle of a boxing match. It was consensual. So uh, you can get the consent of the person harmed, consent to the offense. This justifies the act. The consent must be voluntarily and knowingly. And this is an example of contact sports such as football and boxing. Um, those are a couple of examples of your justification at defenses. And we're not going to go through all of them because this isn't a substantive class, but we're just brushing over it. Then you have your excusatory or your excuse defenses. The first of those, what excuse means is, yes, I did it, but I don't understand what happened, and I didn't do it at my own volition. I didn't know I did it. I don't appreciate what I've done. So the first of those is the age of intent. A minor below a specified age will be excused from any criminal actions. So remember, in a couple chapters ago, I think it's still in this chapter. I'm sorry, where we talked about a crime needing to have an act and a mens rea and an act and a mental state. With age of intent, what they're essentially saying is that if you're under a certain age, you're too young to even have or develop a criminal intent. So just because your age alone, you're going to be deemed not able to be responsible for committing a crime. It doesn't mean you won't be punished or they're not some type of juvenile sanction, but definitely, definitely being tried as a criminal. That's definitely going to be limited because of age. At common law, they had the rule of sevens, meaning if you were less than 7 years of age, you were totally excused. That means you could not form intent. That means you were it was impossible for you to form the mens rea that's needed to commit a crime. If you were 7 years or older, between 7 and 13 years of age, there was a presumption that you could not be accused, or that you can't form intent, but that presumption was rebuttable, meaning that, okay, you're pretty young, so we're going to presume that you can't form intent, but the opposing party can put forth evidence to show that you knew exactly what you were doing. So it's a rebuttable presumption of not being able to form intent or not being able to be held responsible for a crime. Then you have 14 and up. With 14 and up, you're not excused at all, unless there's some other thing that's affecting your mind, like insanity or something like that, which we'll get to. Today, most jurisdictions have modified ages and statutory ages for consent, so it just depends on what jurisdiction you're in and where you are. But age is definitely an excuse defense. Second is insanity. If someone is suffering from a mental impairment or an involuntary intoxication, by involuntary it means you didn't get yourself drunk or you didn't get yourself doped up. Someone slipped you something and now you're out of your mind. But if someone is suffering from a mental impairment or an involuntary intoxication, they may be excused from their criminal conduct for lack of being able to form the required mens rea of the crime. So, the first test is the McNaughton rule, or the right from wrong test. When a person has a mental impairment and that mental impairment rises to the level where the person can't understand the gravity of what's happening, or whether or not it's right, or the right of wrong, or right and wrong, then they're excused. Then the next test is the irresistible impulse test. That is when a person has a mental impairment and the mental impairment rises to the level where they can't control their actions. So even if they understand right from wrong, their mental impairment causes them to not be able to control what they do. So you have certain jurisdictions that have the McNaughton rule, that's the right and wrong. You have other jurisdictions that have the irresistible impulse test. Then you have another one called the Durham product rule, or the product rule. What that means is when a person has a mental impairment and their criminal actions are the product of that mental impairment, then they are excused. So all it means is that their actions must be the product of their mental impairment. Okay, then you have the substantial capacity test. And this is nothing more than a hybrid or a mix of right and wrong and irresistible impulse. When a person does not understand or appreciate the wrongfulness of their conduct or have the ability to control their conduct, they're excused. So that's just a mix of right and wrong and irresistible impulse. Um, Last but not least, we're about to get through this. We have the types of crime. You have crimes against the person. Those are crimes that affect one's personal space and bodily sanctity. Stuff like your assault, battery, homicide, rape, sexual assault, and kidnapping. Then you have crimes against property. These are crimes that affect one's real or personal property possession and interest. Stuff like home, burglary, or arson. And then you have crimes against personal property, such as larceny, identity theft, and shoplifting, where you're affecting the personal property, personal tangible property of a person. Um, Crimes, and then you have crimes against public order and morality. These are crimes that affect the quiet enjoyment and sanctity of society based upon generalized norms of that specific society. Usually, there is not an individual or a specified victim. They're what we call the victimless crimes. The victim is deemed to be society as a whole. This is like prostitution, noise ordinance violation, and stuff of that nature, or disorderly conduct, or unlawful assembly. Then you have crimes against the government, and the book did not include this, but I included this because there's only one crime that is included in the Constitution. There's only one crime that is defined in the Constitution of the United States, and that is treason, and that is to levy war against your own country or aid and assist an enemy combating against your own country. um, So that is treason, and that is actually the only crime defined in the Constitution. Remember that. The only crime that is defined, an act that is made criminal by the U.S. Constitution, is treason. Another part of that historically came from the fact that one of the most, a great officer of the U.S. Army was Benedict Arnold. Um, During the war, we weren't doing that good. We were kind of doing all right. We were kind of making some headway. But Benedict Arnold swapped sides and went to the British. When he did that, that was considered treason, and we actually could have lost the war. Luckily we didn't. But that is the historical context behind why treason was so important at the time they were making the Constitution. They actually put it in the Constitution. So that's treason. So we've talked about criminal law. So that's everything under criminal law. Remember criminal law is the people versus an individual. So you versus everybody else. Now we're going to talk about civil law. Civil law is designed to address private wrongs and settle individual disputes. What is at stake in civil law? Usually monetary or injunctive interest. So monetary means money or property. You got to give something up. Injunctive interest means you may lose the ability or right to do something, or the court may force you or order you to do something you don't want to do, like cease and desist, or give something up, or not see anyone, or there may be a restraining order that says you can't go around a person. That's civil. So it's either monetary or it's injunctive. The burden of proof. Of course, well, let me talk about the who versus who. I meant to do that. In civil law, it's an individual interest versus another individual interest. I'm suing you, me versus you. There's a plaintiff, not a prosecution, but a plaintiff versus a defendant. You owe me money. I'm suing you for that money. Um, I'm filing a divorce lawsuit and I want alimony, or I want my property back. I was supposed to get this, and so it's me versus you, individual versus individual entity. Um, the burden of proof is much lower because the what's at stake is just either you can be forced to pay some money, or you can be forced or enjoined from doing something, what we call injunctive relief. But your freedom is never at issue at civil law. Your freedom or your life is not at issue. So because of that, the burden of proof is much lower. The plaintiff still has the burden of proving liability. So in civil law, we always talk about liability. You hear the word liability. that means responsibility. So you're responsible for some type of damage. Um, and so the plaintiff has the burden of proving liability or responsibility of the other party by a preponderance of the evidence. The defendant has the same burden of proving any counterclaim. So sometimes in civil suits, both parties can sue each other. So that one person sues the other person answers and counterclaims against them. So you have two lawsuits against each other. And you see that if you ever watch People's Court or Judge Joe Brown, you see people that one person will be suing and the other party be suing it as well. So by preponderance of the evidence, what does that mean? That means more likely than not, or by the greater weight of the evidence. Mathematically, what that means is 51% versus 49%. So literally more likely than not. So it's not a very high burden. All you have to do is prove it more than the other side proved it, and that's all you need. There is not some high 99.9 and 100% level of certainty. All to win a lawsuit, all you have to do is prove that it's more likely than not that what you said happened. Tort law. Tort law is a body of law associated with harm caused to someone by the actions of another, where that harm can be quantified and paid back to the victim in the form of monetary damages. Civil wrong and there's civil wrongdoings outside of breaches of contract. So breaches of contract are a whole different side of civil law, and it's not tort law. So with torts, we're talking about intentional torts like assault and battery, conversion or theft, false imprisonment, or negligence. So with negligence is an unintentional tort, meaning there's a damage that was caused, but it wasn't done intentionally. There was a duty, something you were supposed to do, you failed to do it, or you failed to see the risk, and it caused a damage to someone. So you have duty, a breach of duty, causation, and you have a damage or harm that was done. That's the unintentional tort of negligence. So you could kind of hear some of those. So with tort law and criminal law can sometimes cross paths. So you can have an assault where you punch somebody in the face and you get charged criminally, right? You go to criminal court, you can be convicted. The victim can also sue you because you punched them in the face and they want their medical damages back, or they want pain and suffering damages for the pain and the anguish because they had to walk around and couldn't go to work for days because they had a big black eye. So you can actually be sued for criminal actions as well. So there are acts that can be criminal that you can also be sued for. And that's when we talk about wrongful death. And so wrongful death and personal injury claims stem from alleged intentional acts of negligence, or it can be intentional acts. And we'll talk about that, and we'll talk about O.J. Simpson, how he got to where he was, and how he was both charged as a criminal. He won the criminal trial, and then he was also sued for wrongful death, which is a lower standard. And we'll talk about that. We'll talk about how criminal and civil law merge. Then we have property law. Property law is a body of law that is largely the product of English common law that determines the means by which real property, that means land, can be owned, claimed, and protected. Real property is land. We'll talk about real estate. Real property, that's land. Land and the home on the land. You have tenancy in common. That's when multiple parties each own equal share or piece of property. We're not going to go very deeply into that. You have easements, and that is a limited right to use property for a particular purpose. Then the property is not yours, but you've been given permission to use the property for a particular purpose. Adverse possession is a means of acquiring an interest or ownership interest in another person's property simply by using it openly and acting as if it's yours for a certain period of time. You have the nuisance doctrine. A property owner may not use his or her property in such a way that is unreasonable or has an adverse effect on other property owners. Then you have personal property, tangible things that a person can exercise personal control over. Bailment when a person transfers possession of an item of personal property to another person for a particular purpose with the intent and understanding that at some point in time they will get the property back. So that's just property law, not very deep on that. That's all civil law. Then you have contract law, the law governing the conduct of business and agreements between individuals and entities. That's all contract law is. A contract is nothing more than a legally enforceable promise, an agreement between parties where there is an exchange of value or consideration in furtherance or to commence the agreement. You have an offer. In contracts, the three elements are offer. There's an offer to do something, an offer, and then that offer is accepted, and then there's some type of consideration or exchange or signage or exchange of a commitment or what we call reliance. Not all contracts have to be in writing. Sometimes you only need to prove that the three elements of a contract existed. That there was an offer. That offer was accepted, and the acceptance can be shown through reliance or some type of consideration. Then, last but not least, you have family law in the civil law spectrum. So you have four types of civil law. You have tort, property, contract, and family law. Family law is nothing more than law focused largely on the creation of and dissolution of marriages and other interpersonal, interfamily relationships and the resulting changes in fiscal and personal responsibilities between the parties, including parental duties and responsibilities. We talk about in family law, you talk about marriage, divorce, annulment, dividing property, spousal support, and child custody. Those are all the sectors of civil law. So now we know why in civil law there's not much at stake. You're not going to lose your life or your freedom. So the burden of proof is much lower. It is by preponderance of the evidence. Now, when we talk about the merger of how a person can be charged with something criminally and be sued for the same thing. O.J. Simpson, he was charged with the double murder of Nicole Brown Simpson and Ronald Goldman. So he was charged criminally with murder. He was charged with murder, and a lawsuit was filed on behalf of the families for wrongful death. Meaning, with wrongful death, all they have to do is prove that either your intentional or non-intentional actions caused the death of someone else, and now you owe us money for that life that was lost, our family member. So they sued him. So he had a criminal case going on, and he had a lawsuit. Criminal case, much higher burden of proof, and the evidence wasn't that great. And I think his defense team, he had a great defense team, did a great job of showing that they cannot prove his guilt beyond a reasonable doubt. If anything, they kind of showed that there was nothing. There was literally nothing but reasonable doubt. You couldn't trust the cop that did the investigation. The crime scene was badly taken care of. Then just the facts of the case, it didn't make sense. Two people were killed. One being almost like he was a black belt. And O.J. Simpson was older than middle age. He was approaching elderly. I think O.J. Simpson at the time was like 55 years old or something. Used to be a football player. Had a whole bunch of injuries. Couldn't really walk all that well. They're trying to say he killed this strappingly young martial artist. This guy knew karate and was, I think he might have been a black belt martial artist. And they're saying OJ ran up on this dude and slit his throat and cut him up. The whole time while Nicole Brown, his ex-wife, was there, and he killed her too. So they're saying this man killed two people. So the evidence didn't make sense. Now, could he have had something to do with it? Hired someone? Sure. Not saying that didn't happen, but he wasn't charged with that. He was charged for killing them. So of course his criminal defense team, they realized that the burden was much higher for the prosecution. They had to prove his guilt beyond a reasonable doubt, and they just couldn't do it. But at the same time, soon after the murder trial ended, of course, we know history tells us that O.J. Simpson was acquitted. He was found not guilty. But then the civil trial commenced. In the civil trial, the burden was much lower. So because the burden was much lower, meaning now they only had to prove it more likely than not, they were able to still use the same evidence from the criminal trial, but now that evidence wouldn't be tested as much. The hurdle to jump was much lower, so they were able to get a judgment against him. So he was found to be liable for the wrongful death of Nicole Brown Simpson and Ronald Goldman. So he won the criminal trial, lost the civil trial. So that means he didn't lose any life. He didn't lose his freedom, but he did lose money. So he had to pay out this money, and it was a big settlement. He was in debt because he still owed his criminal defense team. So he ended up having to liquidate assets, sell his house. Um, a lot of stuff was sold at auction, including his memorabilia, sports memorabilia, because he was a Heisman Trophy winner, and all that stuff to kind of pay these people off. So literally now they kind of have a judgment against him, which he would never be able to pay back. The only thing they couldn't touch was like his athletic pension, his NFL pension and stuff like that. So that's enough for him to live off of. But anything else, if he makes money, if he still owes them, he has to give them some money. So ends up going to jail later on because he can't. When he does have money, he can't let them know he has money because he owes people. So he wants to use the money he has to get some of his memorabilia back because that's just how athletes are. Great athletes, they do a lot, accomplish a lot. They always want their memorabilia, even though that's just trophies and stuff like that. It's just tangible. It's just a tangible representation of what you did, and it doesn't take it away. But they still want it, right? So OJ Simpson goes in and tries to and work with these mobsters, these illegal dudes, to try to get his stuff back. He pays them an amount of money up front. They say what it is and say just we'll get what you need for I want to say it might have been $50,000. He comes up with 50,000, gives them the money. He said, okay, well when you got it, call me. I'll come get it. So they get it and they call him. They say, hey, we want more than 50,000. He's like, nah, we had a deal, brother. I already cut you a check for 50,000. I'm not paying you anything else. I'm coming to get my stuff. Thank you for what you did. We'll be there in 5 minutes. So of course, OJ, because of the guys he's dealing with, and they're pretty unscrupulous characters, mobsters, he goes with security. So he has 4 or 5 guys with him, big guys. A couple guys got guns. He walks in and says, hey, where's my stuff? An argument ensues, and of course, behind OJ's back, one of his security guards pulls a gun and points it. At this point, because the gun's out, it now can become armed robbery. You're pointing a gun at someone, and it's for the purpose of getting them to give you something. Even though you paid for that something. But that's what landed him in jail. So he got convicted of being an accomplice to an armed robbery, being armed robber. So that's why he went to jail. So that's the O.J. Simpson story in a nutshell, and that's the best example of how you can be sued for criminal acts. So you can take a criminal act, and you can also be in both criminal court and civil court for the same act. So I know I've run over by a couple minutes, but that is chapter 3. So just go over chapter 3. Like I said, the book, you can go through the book's website, www.sagepub.com. That's www.sagepub.com. You can go on their website and you can actually search and put in the title of the book, and you can click on it. It'll take you, and you have to search a little bit, not be lazy, search and see if you can find. But they have the online resources for the book, like online study resource. You can do quizzes. Doing those quizzes for the books, and it's in edge.sagepub.com. You can actually you would have actually done some questions I might use that I am going to use for the exam. Now, not all, some of the questions I'm making up myself, but a good number of the questions are going to come from the online test and review sources. So if you do that for all these chapters, you'll be fine. So you guys take care. Be good.